Here we are, Dan and Brendan, all the talk, constitutional, well, not constitutionally actually, but Supreme Court wise, is about the court's recent opinion. All of us were surprised to hear who wrote it, Justice Gorsuch, and a case called Bostock versus Clayton County.
Surprise?
Yeah.
Surprise? Hey, that's a little understatement. That's like saying the Pope is sort of religious. Surprise? Fell off my chair.
That's right. Because I called you and we talked, as soon as the opinion came out, we talked about it, and I did get the sense that you were about to fall out of whatever you were sitting on at the time.
Yeah, I thought you were under the influence of some serious mind-altering drugs, and I thought I was going to have to call 911 down there, get you some help right away.
Right. Yeah, and you checked the calendar to see whether it was April 1st, right?
Yeah, right. I looked outside to make sure hell hadn't frozen over. I mean, all kinds of precautionary, measures had to be taken.
It wasn't raining toads or right.
Yes, exactly.
So yeah, it was that kind of day, because not only did Gorsuch write the opinion, but the Chief Justice Roberts went along with the majority. So it was 6-3, the court holding that employment discrimination against people based on their sexual orientation or gender identity, transgender status, is sex discrimination under federal civil rights law. Something that I think most of us, those of us who are being honest, most of us would have bet our house that it would be 5-4 in the other direction.
Absolutely, no question.
Yeah, and so we've got three things, most of which Dan thought of. So I'm just sort of grabbing your coattails here. That we want people to take away from the opinion that there's been some talk about these 3 points, but some of them have not been thoroughly hashed out. So we want to spend a few minutes talking about those. The first, Dan, is what is Roberts doing in the majority in this? You had a really interesting take on this. What is Roberts doing in the majority in this opinion?
Well, I think that there are a couple of possible explanations, and I think they probably are both in play, and you're going to do one and I'm going to do one. But the thing that jumped out to me yesterday when I started wondering why is John Roberts on the side of the four liberals in this case is my suspicion is that during conference, Gorsuch probably spoke up and said, I'm inclined to go along with our four colleagues on the other side of the aisle on this one. I do believe that there is a statutory violation here. And Roberts probably wanted to make sure that any opinion that came out of this case wasn't written by Justice Ginsburg or one of the other liberals on the court. The way that the court operates is that if the Chief Justice is in the majority, then the Chief Justice is automatically deemed to be the senior justice, and that person gets to either write the opinion or assign the opinion. But if the chief isn't in the majority, then the senior justice in the majority either gets to write or assign. Well, that would mean Justice Ginsburg would be the one to write or assign the opinion. My suspicion is that Chief Justice Roberts didn't want that to happen. So the way he can sort of cut that off at the pass is by joining the majority, and then he assigned the opinion to Justice Gorsuch, knowing that Gorsuch would write a fairly narrow textualist opinion that would reach the conclusion that he wanted to reach, but wouldn't be overly sweeping. So I think that's one explanation. You've got another one that traces its roots back to Obergefell that I think also needs to be mentioned.
Yeah, and I think as a practical matter, that's a very persuasive, and it's something that I had not considered at first. But yeah, it also came to my attention yesterday as I was poking around about this, that in the Obergefell case, John Roberts, again, the Chief Justice, asked a very interesting question. He never got an answer. And Obergefell, of course, was the now famous case in which the Supreme Court held that states may not deny marriage licenses to same-sex couples. During oral argument in that case, Roberts asked one of the proponents of state laws that do ban same-sex marriage, why is this not a gender case? And he gave a very simple example. He said, if you take three people, Joe, Sue, and Tom, if Sue loves Joe and Tom loves Joe, Sue can marry Joe, but Tom can't, based entirely on the gender of the person who loves Joe.
Right.
And so he asked that question. So why is this not a gender case? Now, by the way, the reason that's important is because gender is considered a suspect classification constitutionally. If there's gender discrimination, then courts apply a very exacting level of scrutiny to any gender discrimination, which would mean if sexual orientation was included as part of gender classifications, that obviously then you'd have a whole different framework for analyzing those cases. So he never got an adequate explanation. Now, when he dissented in the Obergefell case, because he didn't think states should have to license same-sex marriage, he did not address that. But commentators have begun to wonder whether the failure to get an answer to that question led to where he wound up yesterday in the Bostock case. So it could be a little bit that he was inclined in that direction because he had that textual question to begin with, but then when you add on top of it, if he joins the majority, if he was sort of inclined that way anyway, then he gets to assign the opinion, and then he and Gorsuch get the opinion they want, rather than some liberal, what they would call a liberal screed, right?
Yes.
Coming from Justice Ginsburg or somebody who she assigned.
And the point you make obviously sort of begs the question. We don't have time for it today. We can make it into another video, but it begs the question, does this decision, which is grounded in a statutory text and turns on the definition of sex, how does that imprint on our notions, constitutional notions of gender? To what extent is there overlap? That's an interesting conversation that I think we saved for another day, but it's one that's definitely worth having, I think.
Right. So there's the first big point for people who want to be able to talk about this in sort of a nuanced way is why is the Chief Justice in the majority? There are a couple of different reasons why, but that was a real interesting takeaway from the case. The second takeaway, and again, you might want to actually read from the opinion on this. I think it's on page 9, is the way, and then this is surprising too, because Justice Gorsuch is a conservative, but he's wrote an opinion that provides employment protections for people based on sexual orientation or gender identity. And he wrote it in such a way as the sweep of this may go well beyond just the civil rights law from 1964.
Yeah, I think quite frankly, given the work that Justice Gorsuch did, it's impossible to cabin this decision only to Title VII cases. Title VII deals with discrimination in employment based upon a number of characteristics, one of which is sex. But one of the money lines out of his opinion, you'll find it on page 9 of the slip opinion, and I'm just going to read it because it's really quite fascinating. The statute's message for our cases, he writes, is equally simple and momentous. An individual's homosexuality or transgender status is not relevant to employment decisions. That's because, here it comes now, pay attention. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. So it's pretty clear, I think, what that means. Discrimination based upon homosexuality or transgender status is discrimination based on sex. And we can extrapolate that language from Gorsuch's opinion to any number. In fact, to any federal statute or regulation or other text that bars discrimination based on sex. Now, that's not the beginning and the ending points of the analysis, but it is quite clearly the beginning point, and an important beginning point at that, don't you think?
Absolutely. And again, timing wise, we don't have the time to get into every possible maybe we have a series of possible applications of this.
Yes.
But one of the more interesting things people want to think about, again, we don't have time to discuss it here, but all of the targeting of transgender people going on, in particular, the president banning transgender people from military service, but in other contexts as well, healthcare. What ultimately, where does this wind up? So that's
housing, federal housing laws.
Right.
I mean, there are any number of federal enactments that textually bar discrimination based on sex. I think they're all in play at this point.
Absolutely. And then we move to the third point, the final one we'll talk about here briefly, is that first sentence of the opinion, which says what exactly? Sometimes small gestures have unintended consequences. Did I get that right?
Yeah, let me pull it up here. I want to make sure I get it right, because it's one of those cryptic lines that you find in Supreme Court decisions that could mean anything at all or nothing at all.
Right.
The opening line in his opinion is this: sometimes small gestures can have unexpected consequences. What in the world does that mean? Take it, Professor Beery.
Yeah, well, one possibility is, when you hear people who are, let's call it what it is, reformed bigots, oftentimes that's the kind of reasoning you hear from them, right? I was a racist until I got a flat tire on the side of the road, and somebody who was African American stopped to help me, and that small gesture changed my mind. You hear this a lot with sexual orientation, homophobia. Somebody, right, will say, well, I was a homophobe, and then I met some people who were gay, and that changed my mind. So I don't know. That certainly is the most generous interpretation I think one could give to it, at least if one is inclined to see Justice Gorsuch as a decent person who's trying to do the right thing here. But it's possible it might mean something maybe a little bit more ominous.
It could. That's right. People are already starting to talk about what implications this might have, if any, for abortion cases. And there's one of those that's in the pipeline and going to be handed down before too long as well. So there's an awful lot of speculation. It may just be, and this is one of those kind of things where I think, only time is really going to tell. This may just be Gorsuch's sort of Kennedy-esque libertarian streak. This may be his issue, like it was with Tony Kennedy, where he says, when people discriminate on the basis of homosexuality or transgender status, that is nothing but plain old-fashioned animus, and I'm not going to stand for it, for one. That might be what he's talking about. I don't know. Nobody does, but it's a fascinating question, isn't it?
It is. It is. So we'll be talking more about this, but we thought those were the three big takeaways. Number one, how did John Roberts wind up in the majority on this for a 6-3 decision that nobody, I'm going to say nobody saw coming. Number two, the breadth of the holding, how it could apply to other federal statutes and regulations. And number three, that first sentence and what it means. He tried to fit that into a discussion about the civil rights laws, but I think you and I both saw it as a little bit of a non sequitur after that first sentence. So that's puzzling why he started the opinion with that sentence. So we'll be back to talk about this more, but that's enough for this one. So we'll see you for the next one, Dan.
Thanks, everybody.